to ask all members and other in-person participants to consult the cards on the tables for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, including the interpreters. Only use a black approved earpiece. The former gray earpieces must no longer be used. Keep your earpieces away from your microphones at all times, please. When you are not using your earpiece, place it down on the sticker placed on the table for this purpose. And to all members, please wait until I recognize you by name before speaking. And thank you all in advance for your cooperation on that. For members in the room, please raise your hand if you wish to speak. For members on Zoom, please use the raise hand function. The clerk and I will certainly manage the speaking list. I do have my 30-second reminder, and I also have a time is up reminder as well. Okay, for the benefit of the witnesses, I'd like to make a few comments. Before speaking, please wait until I recognize you by name. For those participating by video conference, click on the video conference microphone icon to activate your mic, and please mute yourself when you are not speaking. For those of you in the room, your mic will be controlled by the Proceeding and Verifications Officer. You may speak in the official language of your choice. Interpretation services are available. If you have the choice of either floor, English, or French for your earpiece. If interpretation is lost, please let me know right away and we'll get it back on track. Okay, pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, November 27th, 2023, the committee will commence its study or continue its study of coercive behavior. Before we welcome our witnesses, I'd like to also provide the trigger warning that we will be discussing the experiences related to violence and coercive control. This may be triggering to viewers with similar experiences. If you feel distressed or need help, please advise the clerk. For all the witnesses and for all members of Parliament, it is important to recognize that these are indeed difficult discussions, so let's try and be as compassionate in our conversations as possible. At this point, I would like to welcome our witnesses. As an individual, we have Jennifer Caution, Professor, Faculty of Law, University of Calgary, joining us by video conference. From le Regroupement des Maisons pour Femmes Victimes de Violences Conjugales, we have Karine Barrett, lawyer and project manager. We also have Louise Rondeau, co-responsible for political affairs. And from the Women's Legal Education and Action Fund, we have Roxanne Parsa, staff lawyer, joining us by video conference. You will each have 5 minutes for opening remarks following rounds of questions. I will give the floor to Ms. Caution to start, and then we'll give the floor to Ms. Barrett and Ms. Rondeau for a shared 5 minutes, and then to Ms. Parsa. So we'll begin.
Thank you very much for the opportunity to engage in your committee study of coercive control. I'm joining you today from Treaty 7 territory in Mohkinstsis, which is the Blackfoot word for Calgary. I'm speaking today on my own behalf, but I did file a submission with the Standing Committee on Justice and Human Rights for its study of Bill C-332 with 3 co-authors in March 2024. Our submission raised concerns with the criminalization of coercive control, and I will not repeat those concerns in these opening remarks, but certainly welcome questions on that subject. In my time today, I'll focus on research I've conducted with colleagues Janet Mosher and Wanda Wiegers that examines how coercive control is being interpreted and applied under the Divorce Act. This research reveals several concerns, 2 of which I'll highlight today. First, coercive control is being used against survivors. We found several cases where coercive control has been interpreted broadly by family courts.
I'm sorry, we're going to have to interrupt just for a moment and suspend. We have a situation with earpieces. There's several that are not working, so I'm terribly sorry that I have to interrupt you, but if we can just suspend for a few minutes to get earpieces working. Okay, Ms. Koshan, you can continue, and of course, we paused your time, so you can carry on right where you left off. Thank you.
Thank you. So again, our first concern is that coercive control is being used against survivors. While it may seem like a positive development that coercive control is being interpreted broadly by family courts, findings of coercive control are being made against mothers who seek to protect their children from family violence by limiting contact with abusive fathers. So-called parental alienation arguments are often raised by fathers in response to claims of abuse, and courts are sometimes finding women to be perpetrators of coercive control simply for trying to protect their children. In other cases where women's claims of abuse are not substantiated, this too can be construed as family violence on their part, based on myths and stereotypes about false allegations of violence being made by women who are seeking purported strategic advantage in family law proceedings. These cases reveal a failure by courts to understand the difference between protective behavior by mothers on one hand and actual coercive control by fathers on the other hand. They also confirm not just the challenges of proving coercive control for abused women, but how their inability to prove coercive control can be used against them. In this respect, our research supports the recommendations of the National Association of Women in the Law about the need to limit arguments of parental alienation before family courts. Overall, the family law system indicates that judges are struggling to understand coercive control and the types of evidence that can help establish it. Education of all legal professionals is required and must be undertaken before any new offense of coercive control is implemented in Canada. A second concern is that survivors need supports to protect themselves against litigation and systems abuse, including in family law cases. We know that abusers often use litigation as a way of furthering their coercive control. In the criminal law sphere, there are protections for complainant witnesses, such as limits on cross-examination by self-represented accused persons, and the option of testifying behind a screen or with a support person if permitted by the judge. However, this type of protection does not exist in the Divorce Act. To provide an example, we came across one case from 2023 where a self-represented father who was found to have engaged in family violence was permitted to cross-examine his wife for 7 days. While the judge permitted her to testify behind a screen, that ruling was discretionary, and we found that this type of measure is rarely ordered in family law cases involving claims of coercive control. This type of litigation conduct can itself amount to family violence, yet as noted, it's rare for courts in the family law realm to place limits on it. Our Divorce Act research therefore shows that amendments are required to limit this type of abusive litigation conduct by restricting personal cross-examination and allowing testimony behind screens and with supports for family litigants. By way of comparison, in the United Kingdom, reforms to the Domestic Abuse Act in 2021 allow courts to put these types of special measures in place to protect survivors of abuse in family law proceedings. And some Australian states do as well. Overall, we can glean lessons from legal responses to coercive control from other jurisdictions, but also from within Canada when looking at how the Divorce Act is being implemented. We also need to be mindful of how women experiencing intersecting inequalities can face challenges with having their claims heard and accepted in ways that are trauma-informed and informed by principles of substantive equality. Thank you, and I look forward to your questions.
Okay, Karine Barrett.
Bonjour. Thank you very much, the committee, for hearing from us today. Our regroupement has 46 shelters for women who are victims of domestic violence throughout Quebec. Each year they provide shelter for some 3,300 women and almost 2,000 children, offer nearly 30,000 services without accommodation to these women and children, and in all they respond to nearly 90,000 requests.
Yes?
I'm so sorry, Chair, I'm not getting translation.
We'll just suspend for a minute while we sort out the translation. Thank you. Again, I apologize for the disruption. Continue.
Okay. Le contrôle coercitif.
Coercive control is not a new form of domestic abuse, nor is it a synonym for psychological abuse. Rather, it is a broader vision of domestic or family violence. The main reason for seeking services in our shelters is not physical violence, but rather other forms of violence. And of all the women who receive external services, over 44% report experiencing post-separation violence. Thanks to a grant from Women and Gender Equality Canada, we're carrying out a project aimed at ensuring that the various judicial players integrate the concept of coercive control into their practices. More than 20 years after the launch of the project, the results are numerous. First of all, we've created a toolbox for these different actors and a booklet for the women themselves. Also, more than 6,000 professionals have been trained to better detect the issue of coercive control, and as a result, coercive control strategies are beginning to be noted in police reports. There's also a better understanding being observed of the risk linked to coercive control by the actors, in particular to prevent homicides. In addition, the Ministère de la Sécurité Publique in Quebec has enhanced the victim impact statement in order to include elements of coercive control, and has also broadcast a webinar for all police officers across the province. And there's also a police placemat to be displayed in all police stations in Quebec on this very subject. Also, Directeur des Poursuites Criminales et Pénales, the head of criminal prosecutions in Quebec, is asking prosecutors to take into account the presence of coercive control when dealing with these cases of violence. And finally, there's also a shift in the media conversation on how they actually talk about domestic violence. These changes leave us confident that the judiciary will be better able to take coercive control into account. The regroupement is actively advocating for the criminalisation of coercive control and supports Bill C-332 as amended by the Standing Committee on Justice and Human Rights. For us, this criminalisation would help to validate the experience of victims and their children, show that this behaviour is socially unacceptable, and would mark an important step forward in women's rights to safety, but also to dignity, autonomy and freedom. This new offence would also provide additional leverage for legal professionals to break the cycle of violence earlier and intervene appropriately when faced with the dangerous situation of domestic violence. Last year, we met with professionals from England and Scotland to identify the lessons learned from the criminalisation of coercive control. All agreed that they would not go back in time. In a few days' time, in fact, we'll be embarking on a new mission ourselves to gain a better understanding of the progression and treatment of offences involving controlling coercive behaviour. This criminalisation must nonetheless be accompanied by the conditions necessary for it to succeed, including, firstly, gradual implementation to enable the judicial players to prepare for its entry into force. Secondly, invite victims to consultation sessions, including those from Indigenous communities, and, of course, providing additional additional human and financial resources so that actors involved have the concrete means to bring about the expected changes in their practice, also ensuring the implementation of awareness raising and training activities amongst all the stakeholders within the justice system, including the Conseil de la Magistrature, the Judicial Council in Quebec. To do so, they should draw on resources specialised in domestic or family violence and implement a public awareness campaign. Also, to continue work on the effective implementation of the National Action Plan to end gender-based violence, including accessibility to resources to support and accompany victims, as well as adequate and recurrent funding thereof. Finally, to assess legislation at regular intervals in collaboration with resource experts in domestic violence and survivors. Other measures are essential to enable women and children who are victims of domestic violence to escape from this, namely the rapid development of social housing, making available a resettlement assistance fund for victims, as is happening in Australia, and also facilitating their access to a decent income. The regroupement also welcomes this initiative by the Standing Committee on the Status of Women, since by studying this concept of coercive control, you're enabling a better understanding and recognition of this concept, and this allows us to protect victims. Thank you.
Excellent. Thank you so much. Next, we have Roxanne Parsa for 5 minutes.
Good afternoon. My name is Roxana Parsa. I'm a staff lawyer at the Women's Legal Education and Action Fund, also known as LEAF. I'm grateful to appear today from what is now known as Toronto, which is on the traditional lands of the Mississaugas of the Credit, the Wendat, Anishinaabe, and the Haudenosaunee nations. As you know, LEAF is a national charitable organization that works to advance the equality rights of women, girls, trans, and non-binary people through litigation, law reform, and public education. For almost 40 years now, LEAF has advocated for the need to improve the justice system's response to gender-based violence. Thank you for inviting me here today to speak about coercive control. We are glad to see this issue being the focus of study at this committee. As this committee has heard, coercive control is prevalent across societal lines. This can present as a pattern of abuse through threats, intimidation, control, and induced fear, often over a span of many years. Coercive control can creep into and impact every aspect of someone's life: their financial freedom, their social life and community connections, physical freedom, even elements such as immigration status being used as a threat. These patterns must be recognized as an insidious form of violence that can have devastating consequences. However, it is this very nuanced and complex nature of coercive control which also makes a criminal legal response challenging and raises significant concerns about the implementation of any law. A frequent lack of physical evidence means that recognizing the existence of abuse requires an understanding of the nuances and context of a relationship, often over many years. How can a survivor show these layers of control to a police officer or provide enough evidence of psychological harm to meet the burden of proof required by a court? Even when an arrest occurs, the experiences in the United Kingdom have shown that the vast majority do not lead to charges, let alone to a conviction. Moreover, how can we ensure that the police officer's discretion is being used in a manner which recognizes the subtle abuse when it is pregnant? The existence of systemic oppression, including histories of colonialism and racism embedded within the justice system, significantly heighten the potential for error or misapplication of law. We've seen similar risks arise in the past where mandatory charging policies have resulted in charges being brought against survivors of violence. Moreover, we know that the criminal law and the legal system broadly continues to fail survivors of gender-based violence. These systems are not providing justice, nor are they leading to more safety. We regularly hear about survivors who continue to be re-traumatized through their experiences. Relying on the criminal legal system as a response to abuse may in fact unintentionally exclude many from even seeking assistance. Potential for harm is particularly heightened for survivors from already vulnerable communities, such as Black, Indigenous, disabled, or non-status peoples who have valid reasons for distrusting these systems. This only deepens the existing inequalities which exist. The law does not exist in a vacuum, and we think it's important to think about the realities of who is able to access the law and how it will be applied on the ground. This is why, instead of focusing on the criminal law, we strongly recommend a diverted focus on prevention and education. This means providing increased funding for shelters and transitional housing, in addition to funding affordable long-term housing for survivors to have places to live when they leave their relationships. We need ongoing and sustainable funding for social services to provide trauma-informed anti-oppressive services like mental health care or childcare so that survivors know they have places to turn for support. We also need more funding for programs like legal aid and independent legal advice so that survivors can get the legal assistance they may need to help figure out their options. We also echo the many witnesses who have advocated for more education. We need mandatory training for actors in the justice system on coercive control, as well as ongoing training on systemic bias and racism. We also need public education about coercive control so that survivors and their communities can recognize these patterns and feel validated and understood that it is being recognized as abuse. For decades now, the increased rates in gender-based violence have consistently shown that turning to the criminal legal system has proven to be an ineffective response. We think it's time that we turn to focus on resourcing our communities and systems with the infrastructure required to create real safety for survivors and to allow them to move forward. Thank you for your time, and I look forward to your questions.
Thank you all very much for your opening remarks. We'll proceed with questions from members now. I'd like to begin with Anna, 6 minutes.
Thank you, Madam Chair. So my first question is, I'm is it Jennifer? Yes. So the comment that you made about education, I think that's important. I think we do have to educate not just the men in our lives, but also the judges and the lawyers to better understand what coercive control is. So I'm going to refer to the importance of this on behalf of the children, because they end up being the victims as well as the mothers in all of this. So I'm going to take you to an event that occurred on Christmas Day, December 2017. Chloe and Aubrey Berry, ages 6 and 4, were found by police in a ground floor apartment in Oak Bay. They were murdered by their father. The mother, if you read through the court case, the mother was continually trying to advise the courts, and nobody listened. What advice would you provide to the courts today? And this is just one of many cases that occur. How can we change that to criminalize the father because we're not protecting our children?
Thank you very much for that question. Yes, so the Berry case is a very disturbing one, and sadly one of only many cases where children have been killed by abusive fathers. And something that we found in the Divorce Act research that I mentioned is that even though the Divorce Act now requires children's exposure to family violence to be taken into account when making parenting orders, it seems that courts are still really struggling with understanding what that means. And so in many cases, what they look for is that children have been directly exposed to violence, rather than also considering how children's indirect exposure to violence can have a very adverse impact on them. And so what we see is that it's very rare for things like supervised parenting orders to be made by the courts. And even if it is a case where criminal charges are laid, eventually if a person is incarcerated, they get out of jail. And so I guess what I'm encouraging the committee to do is to think not only about the criminal side of things, but to also think about the family law side of coercive control and the need for courts and legal professionals to be educated so they understand the impact on children, and the need sometimes for parenting orders to be supervised to try to prevent these types of killings in the future.
But if we don't incarcerate them and have them go through treatments while they're incarcerated, how do we protect the children is what confuses me, because if they pay for their crimes, and if we educate them and work with them, hopefully they'll come out and be better people. Do you agree?
Well, I think training and counseling and those types of things can also occur without incarceration. And so in Alberta, where I'm from, our domestic violence courts use peace bonds quite regularly, which means that people are not incarcerated, but if they admit responsibility for the offense, they're still sent to treatment. There's mixed evidence, though, on whether that type of treatment works. And so again, what I'm encouraging is that criminal law be looked at alongside what happens in the family law realm, so that we can be thinking about how these two systems work together, and the fact that sometimes we need to have protections in the family law sphere, even if there has been treatment and or incarceration in the criminal sphere.
Thank you. So I'm going to ask Louise the same question, if you wouldn't mind. I mean, we could look at many cases. We could look at Kira's Law, which is the same situation. The father was very controlling. The child was ignored. The mother was ignored. And we had another tragedy. We have to ensure that we protect the victims. How can we do that if we don't control the men that are, doing the crime?
Vous avez raison de dire.
You're quite right when you say that there's a big challenge when it comes to family law as well. Every day we see that often lawyers, or rather judges, think that violence is towards the women, but there's no violence towards children if it's not direct. And incorrectly, we think that violence stops when their couple separates, but in fact, often that's when it becomes most dangerous, when there's a separation. So there needs to be a dialogue between the criminal law side of things and the family law side. And family law has to recognize that the presence of domestic violence is dangerous for the women and children, and measures need to be implemented. Often we talk about shared custody. That's a situation that obliges the parents to often remain in contact one with the other because of the link with children. That multiplies opportunities for controlling spouses to exert violence towards their ex-partner or the children.
Okay, so I would also like to ask Karina the same question, because there was another incident in the mid-90s where a father was supposed to have supervised visitations with his children. He then in turn, and the reason they separated was because he was very controlling. Not only did they lacked the supervision, he ended up killing his 4 children, shooting himself, and before doing that, burning up the house. So again, he went through some kind of treatment, but obviously it didn't work. How do we protect, as society, protect our children?
Anna, unfortunately, your time has been exhausted, so perhaps you can incorporate her answer into somebody else's. Okay, thank you. Second, we have Pam. You have 6 minutes as well.
Thank you, and it's a pleasure to be subbing in on this committee again for such an important study, and I commend the members of FEWO for doing this. Professor Koshin, you brought up parental alienation. I recently sponsored a petition on this and looking for changes to the criminal code, but I wondered if we could maybe talk a little bit about parental alienation, because one of the things that came up in my meetings are reunification camps and how these are much like coercive control, much like conversion therapy, being used to send young children to the United States to camps at tens of thousands of dollars of cost to the mums, to basically convert them to reunite with an abusive partner. So I wonder, do you have any comments on that, on whether or not you think the federal government should do something, whether legislatively or through regulations, about these reunification camps?
Thank you very much for that question. As I mentioned in my opening remarks, I think our research on family law very much supports the recommendations that have been made by the National Association of Women in the Law about the need to limit parental alienation arguments in family law cases, because often they are raised in response to allegations of family violence by women. And you're absolutely right that we sometimes do see judges buying into this notion of parental alienation, when really what a mother is trying to do is protect her children from abuse. And then in cases that are considered extreme, these reunification camps occur, which are extremely harmful to children. And so, yes, I would urge the committee to think about placing limits both on the extent to which these types of arguments can be made in family law proceedings, but also the types of remedies that can be ordered. And I believe there really do need to be limits placed on these types of reunification, so-called therapies.
Yeah, I'm familiar with the NAL's recommendation, and I've met with them and am very supportive of what they're looking for. The one thing that the mums and children that have been subjected to these camps said that if the reunification therapy and reunification camps were ended, it would stop the money train, and it would actually help in judges not recommending. And I don't know, I know I'm directing my questions at you, Professor Koshin, because you brought it up, but if Leaf or anyone else wants to jump in, you're more than welcome to.
Maybe I'll just briefly make a plug for Lyndon Nielsen's research in this area, because she found that sometimes the people who are testifying as experts in parental alienation cases are the same people who run the reunification camps, and they stand to profit directly from those camps.
I'll go over to you in just one second, but these camps are tens of thousands of dollars, and the charge for them is being charged to the mums, who often have to mortgage a house, or we're not talking about small amounts of money that are being the cost to try and fix these kids. And talking to these young people who've been subjected to these camps or therapy, it's absolutely horrible. You wanted to add to that?
Oui, mais je pense que au-delà.
Yes. Over and above banning these camps, work has to be done to educate the courts and the psycho-legal experts. When a woman is trying to protect their children, when a child says that they don't want to see their father because they've experienced violence or observed violence, we need to listen to the child. We're starting to now talk about judicial-based violence. That's one way that the spouse actually exploits things to continue to control their partner. So we completely agree with these recommendations from the National Women and Law Association to actually ban the use of parental alienation. It's a concept which is not scientifically based. Unfortunately, it's been adopted by too many family and youth courts, and we think this is simply a way of maintaining the status quo and maintaining the power of fathers who are controlling and violent.
I think there's two issues, though. One is the null recommendation about banning parental alienation in the law, but then there's also getting rid of the reunification therapy. Would you agree with that? The actual therapy in camps? You're shaking your head. Yes. Okay. One of the issues we have with mandatory training, though, is, and this committee studied Keir's law, thanks to MP Dillon, and I worked on that. We can't mandate training for judges, and I'm very grateful that the province of Ontario has implemented Keir's law, as has Manitoba. I would encourage Quebec to do the same, but we're really limited as legislators in requiring training for judges, and a lot of the people who need training actually fall within provincial jurisdictions, so children's aid societies and Crown prosecutors, and I think we've come a long way thanks to MP Dillon's private members bill and the work of Jennifer Kagan, but we are limited in as educators on training, and I think I have about 15 seconds left, so I'll end it there. Thank you.
Thank you. Perfect. Adrienne, vous avez 6 minutes.
You have 6 minutes now, please, Adrienne. Thank you very much, Madam Chair, and thank you to the 4 witnesses for being here today on this study. And unfortunately, current affairs remind us in quite a dramatic way that we absolutely have to do more to not have any more of these incidents occurring. Once again, this morning, Madame Stéphanie Legrand in La Presse came out with an article where she was recalling the figures which are really alarming in Quebec at the moment. And quickly, because we've just dealt with the question of education, so I'd like to turn to Ms. Barrett or Ms. Riendeau. Perhaps. Well, I discovered this tool last summer when I was thinking about how I could bring up the study in coercive control before the committee. And that complements basically the work on coercive control, because we know it's not a magic wand. It's not going to resolve everything, but there's a whole continuum of services and solutions to be proposed. So could you talk a bit more about your toolbox, your tool, please? Thank you very much for that question. Since October 2021, we've been working on this project mentioned by my colleague, and we work with an advisory committee made up of 30 members, amongst all the judicial actors from the police services, the National Police School, university researchers, and shelter workers, jurists, prosecutors, and it's also important to the correctional services involved. The idea was to develop tools that would really meet their needs on the ground. So first of all, to understand coercive control with their respective missions, and then to look at the limits on the ground. So over and above understanding this, we had to see how they should detect this. It's different if you're a lawyer advocate or an immigration advocate or somebody out on the beat. And then there was a question of the level of dangerosity that had to be understood. So we developed a toolbox and this placemat, which talks about the different tactics, different manifestations. The committee wanted to give specific examples and say, if I've not experienced this, what does it actually mean, this gaslighting? Or all of these questions were developed on the ground. So we developed this to support actors. And as my colleague has said, we've got this placemat for the police to help police services when they're drafting reports so that they can mention what they've observed on the spot. It's also used by others. It's had a major impact. And we've also seen this for women that are in economic precarious situation or those who are from different ethno-immigrant groups. Over and above education, we have to try and help them to get out of this violent cycle. Unless we can get them out of this economic poverty-based cycle, this precarious cycle, which means that often these women are stuck in this domestic violence cycle. But I'd like to come back to the article from this morning because it really gives us shivers down our spine when we read these statistics. We're talking about Nima Rozek, who was stabbed last Saturday by her ex-spouse, the 3rd in 4 days and the 14th in Quebec, to be killed within this context of domestic violence. So in the last 5 months, the number of femicides is already higher than for the whole year of 2023. You have said that you have been consulted for the drafting of that article in La Presse. And when it comes to the coercive control study, I know that you've been consulted for this article, and you also contributed to the report called Rebuilding Confidence in Quebec, which has led to various initiatives being developed. And it's Emily in Quebec who basically said that now the federal level has to run with the ball. There's been a great deal that's been done at a provincial level, but when it comes to coercive control and criminalising it, the ball is in the federal court. And we see these figures, and we see that coercive control and criminalisation of this could be a useful tool to actually reduce the amount of crimes committed against women. Well, that is why we're really happy to see that you're pursuing this study. We have to talk about it. We have to make sure that people talk about this. Sometimes victims in general, they know what they're experiencing, but many professionals still think that when it's domestic violence, it's all about physical violence. But in fact, we know there's all different forms of violence and control that are present. And we know that coercive control is an indicator of lethality. There was a study that was carried out in England that showed that in over 90% of homicide spouse-based cases, coercive control had been present in the past. So that means that the population needs to be made aware of this situation, and in particular, professionals need to be made aware of this concept of coercive control so that they can then help victims in turn and push perpetrators to change their behaviour. And in that way, we'll be able to document this, talk about it, and then take measures to counter this rather than treating it in a banal way. Because it may look quite banal if we look at it individually, but people have to be better informed and counter this and recognise it as a form of violence. Would you like to add something, Madame Barrette? Just a few seconds? Or there was a sentence you said there's not one country that's pursued the criminalisation of coercive control that wants to go backwards. So what have you learned from that? Well, to come back to what the other witness said, all actors can help in detecting this. Victims are not always aware of this when there's an absence of physical violence, that they're actually a victim of domestic violence. But when you can recognise coercive control over and above physical violence, judicial actors, family, criminal law can all get involved and actually help out the victims in their particular situation.
Next, we have Leah Gzen. You have 6 minutes.
Thank you so much, Chair, and thanks to all the witnesses for being here today for this very important study. My first question is for Professor Caution. Would you recommend to the committee to not criminalize coercive control?
Thank you very much for that question. So that is the position that I took with my colleagues in the brief that we filed with the Standing Committee on Justice and Human Rights. Our concerns, I mean, we totally understand that coercive control is a real concern, and that we need to think about legal responses to coercive control. But we share some of the concerns that were mentioned by Roxana Parsa from LEAF in her opening remarks, that we have learned some lessons from things like mandatory charging and prosecution policies for domestic violence.
Sure.
We also bring to the table some issues with how family law is treating coercive control, and it is being used against women. Women's protective actions.
Professor, sorry, because I have limited time. So
Yes.
yes, you agree that we should not criminalize coercive control, yes or no?
I agree with that.
Okay,
not at this time.
Not at this time.
We need more
perfect.
work to do.
And I'd like to now go over to you, Madame Parsa. Would you also agree to not criminalize coercive control?
Yes, we do agree with that. And we also submitted a brief to the Just Committee, which outlines more in depth our submissions.
Okay, I have another question for you. One of the things that I've put forward, you were talking about, let's instead focus on prevention, or, ways so that people exiting violence can actually do that. One of the things that I put forward that will be voted on in the fall is to put in place a guaranteed livable basic income. Do you agree that we need a guaranteed livable basic income as one ways to deal with the gender-based violence crisis?
I think absolutely having a basic income, along with having affordable public services and housing and increased social protections, all of this would assist in helping survivors know that they can be safe if they need to leave their relationship.
So you agree, you would recommend a guaranteed livable basic income in addition to other supports and services meant to meet specific and special needs?
Yes.
Okay, thank you. Over to you, Ms. Caution. Would you also agree?
Yes, for the exact same reasons mentioned by Ms. Parsa, I agree that that's a very important way of ensuring social and economic support.
Okay, wonderful. And I don't, my apologies, I don't have the names of the other two witnesses in front of me. I'm just looking up. Would you also agree, Madame Barrett and Rideau, that a guaranteed livable basic, would you recommend putting in place a guaranteed livable basic income in addition to other supports meant to meet specific and special needs as a key action to deal with gender-based violence and people fleeing coercive control?
Absolument, l'accès à un revenu décent.
Absolutely. Access to decent income, access to affordable social housing that's safe, and access to different social policies are essential elements to allow women who are fleeing violence to be able to actually do this in an easier way.
Okay, thank you so much. Madame Caution, you spoke a lot about parental alienation. Do you believe that courts should not be able to use parental alienation as an argument in cases?
Yes, I agree with that. I have a bit of a caveat, if I have 1 second to mention that. I think there needs to be a distinction made between parental alienation allegations made against mothers and what we sometimes see from fathers, which is an actual sabotage of children's relationship with their mothers, which is itself a form of family violence. So I think we need to keep a distinction between those two different types of practices. And if we can do that, then yes, I think parental alienation arguments should not be permitted in family courts.
Ms. Parsa, Madame Parsa.
Sure. At this point, LEAF does not support a full ban on parental alienation, just because we need to do some more internal work on establishing our position on this. But we do think it is certainly extremely important for courts and judges to be educated on the ways in which litigation is used as a form of abuse. And that's actually one of the things that we're afraid of if coercive control becomes a new criminal offense, that will also be weaponized against women as a form essentially of coercive control. So we think it is crucial that courts and members of the legal system are educated and continue to learn about this.
So you recommend educating courts and others about what parental alienation is?
Absolutely.
Okay, wonderful. How much time do I have?
Leah, you have 4 seconds. That would be
4 seconds.
if you would like to.
I did not to see your clock.
I know you did.
but I did.
Perfect.
So
Thank you for that. Michelle, you have 5 minutes.
Thanks, Chair. And thank you to our witnesses today here at Status of Women, aka FEWO, as we study coercive control. And, you know, we've seen a drastic rise in domestic violence. We've seen some wild stories that my colleague and around the table, all the women here today have shared. I guess I'll start with you, Ms. Koshin. I think it would be beneficial in this report to have a definition, because you've outlined this, between a protective mother, and I also always, for the record, want to say this does happen to men. I always want to say this can happen in anybody's, but we are focusing on women here. The difference between a protective mother versus coercive control and the definition, because I think the definition is a key part of this conversation.
Yes, and it's challenging to do in the limited time that we have, but
you are very welcome to submit a written
yes.
Because I do understand this is very big, and it's like, oh, in 10 seconds, tell us about. You know, I understand that. So if you want to submit a written submission, we'd love to have it as well.
Yes, thank you. And maybe what I'll do, just to try and put a fine point on it, is to say coercive control, in the way that it's understood as a form of intimate partner violence or family violence, is all about the impact that it has on the autonomy of the victim. So a pattern of conduct that has an impact on the autonomy of the victim. Whereas if we think about mothers' protective conduct, they are not engaged in that conduct in order to impair the autonomy of fathers. They are trying to protect their children. So in part, it's, I think, a difference in the intent behind the conduct, what they're trying to achieve through the conduct. And I think there is a real distinction to be drawn between attempting to protect one's children and attempting to control one's partner in a way that impairs their autonomy, if I can put it.
Yeah, and I think you've pointed out the challenge here in itself of the complications of this and why it is so important that judges would need to be so critically educated in this, because there's a nuance here, and anybody who has had experience in an abusive relationship, sometimes the abuse or the toxic relationship between the intimate partners is vile, but they're able to have relationships with their children, or the children need to see each parent. But the system is set up right now that the children are pawns for money, for all of these things. And where I want to go with this is this cost of living crisis that further alienates or forces women into abusive relationships. Like, you have stats now, this was a National Post article, divorce rates in Canada falling because Canadians simply can't afford it. So we already know, like, money is one of the biggest reasons you can't leave a relationship. If they're having financial control, which thank you for these great handouts. They're super helpful in educating the public in terms of the definitions. And for so many people, they don't even know they're in an unhealthy relationship because that's all they've ever known. And the children don't know. So when we want to intervene and sort of pull that apart and break that pattern, and then you have articles like this saying, the main reasons wedding bells aren't ringing seems to be the hefty price tag and the overall cost of living, or the inability to be able to afford to leave, or the access to housing. So I guess I see, the witnesses in here. I don't know who wants to chime in on that, but I'd love to see something in the report around that, because this cost of living is a very, very big factor in allowing women to break free from abusive relationships. I see Louise making eye contact, so I'll just ask Louise.
Mais effectivement, nous, on
Yes, we are seeing that certain women who are asking for help from the shelters do decide to go back to their violent spouse because it's impossible for them to find affordable, safe housing that will allow them to continue to feed their children, bring them up, and clothe their children. So these are key issues. And every day we've seen that as the housing crisis increases in Quebec, women remain longer in shelters, which causes other knock-on problems. That means that other women then cannot come in to the shelters. So we absolutely have to work on the economic situation and the economic autonomy of women, give them access to jobs that will allow them to have that type of freedom. Also, to work on the fact that seeing these signs of control, sometimes spouses force women to leave their jobs or deprive them of financial resources. That's something that has to be detected as well if we want to help women. Thank you.
Next, I'd like to welcome Anita to ask questions.
I would really like to thank all of the witnesses, because I think your testimony today has been extremely helpful, not only in discussing how we can remedy this, but also in what exactly it is. And I think that we've skipped a little bit in this committee from, what is coercive control, right, to what can the government do, what can the justice system do, how do we educate, but we haven't actually gotten on record exactly what it is that we're talking about. And we've had witnesses here to talk about financial and economic abuse. We've had witnesses talking about, of course, physical violence against women and girls and non-binary, gender-diverse people. But what exactly is coercive control? And before you answer that, specifically right now to Madame Riendo and Madame Barrette, you did hand out something that I just glanced at and find very useful. I hope you will table that so that it becomes part of our official documents of the committee. But it talks about monitoring and interrogation, threats, sexual violence, gaslighting, financial abuse, spiritual violence, harassment, humiliation, abuse using technology, blaming, physical violence, isolation. These are things I suspect that people who know people or who have personally experienced coercive control would know instinctively, but not necessarily be able to articulate or even describe to others, particularly judges and others. If I could just give you a few minutes to put on the record, what exactly are we talking about with coercive control?
Si je peux y aller. Dans le fond,
Yes, I'll jump in. When we explain this, the definition that we give is that coercive control is a pattern, a continuum of tactics and strategies, manifestations of violence and exploitation with the aim of terrorizing and dominating the victim, deprive them of their rights. As other witnesses said, there's a real intention behind this. It's often done in a gradual, sneaky way by a partner or an ex-partner, and it's repeated over time. So when you have a good grasp of coercive control and what it means, you're not going to mix it up with a protective conduct, because you see there's a difference in intention. So we're not saying that it's just like an argument with your spouse. No, it's something that takes place over time. It's a taking over control rather than losing control. It manifests in lots of different ways. You've referred to our tool here where we give various examples on the placemat. It's not restrictive. There's no limits on this. And sometimes when a perpetrator of violence wants to use one type of tactic, if it doesn't work anymore, or if the victim wants to take back power, then they'll add in another tool from his particular toolbox and perhaps then use physical violence. For example, there can be a coercive control situation where there'll never be any violence because it won't be necessary, and often the victims will be experiencing coercive control without realizing it. So we've developed a tool where we've said it's not love, it's control. And victims have said, when I look at resources, when I look up domestic violence, I don't read that to be my situation. He's never been violent, he's never touched me, they say. But when we give them this tool that really stirs things up, and then when we go out to the media and when we talk about coercive control, we get calls coming in afterwards and people say, yes, that's exactly what I'm experiencing. I thought I was going mad. He said I was just exaggerating, that I had a problem with my mental health. He said to my family that I was very sensitive, but in fact I can see that he's actually weaving this web around me. But there was no physical violence. Sometimes there is, but when there's no physical violence, it's very hard for victims to be aware of this. So judicial actors need to be informed about this, and then they can be sentinels and inform victims about what's actually happening to them. Sometimes it's not like criminalised procedure. It can be via immigration or a family law step, or with notaries and lawyers. Everyone needs to be aware of this so that they can render something visible that's invisible for the victim. And we've created tools for various judicial actors so that they can put the right questions, so that in family law they're able to document when there's coercive control, to raise this with the judge, and with immigration they're able to see the specific ways in which the spouse is actually controlling their partner who has precarious status.
This has both talked about education as being very important. I wonder if I can go to you if there's any time, because what you're describing talks about intention and a pattern, which doesn't really bode well in terms of the judicial system, the criminal justice system. So if I could perhaps start with Professor Koshan to talk about, because I know you said criminalizing is probably not a good idea, but talk about the education component.
Sadly, Anita, your 5 minutes is up. I would welcome that testimony to be added, but perhaps somewhere else in the next round. Adrienne, you have 2.5 minutes.
Merci, ma'am. Thank you very much, Madam Chair. So I'll continue with Ms. Riendeau and Ms. Barrett to follow on from what you've just said. It's not because it's always striking and because it's not hurtful that it's not there. Sometimes with coercive control, it doesn't necessarily lead to femicide, but we are very much interested by this issue, and perhaps you can add to what I've just said. But I'd like to come back to an aspect that hasn't been raised much about C332. You referred to that in your opening remarks. This bill that you support, and there was a colloquium about violence against women in my region, and groups were very interested in this type of bill. But there's criticism around this. There's certain nuances because this bill wouldn't resolve all the problems, even when we're just talking about coercive control. So would you like to come back on my first comment, and then could you share any proposals you have on this specific bill? Thank you very much. On the first point, when we said it's not because there's no physical violence that it's not a danger, well, there's a US statistic which says that in a third of cases where there's an attempt for spousal-based homicide, there was no physical violence beforehand. So when we're training police officers, we're saying don't wait to have assault or physical violence to imagine that it's dangerous. So that's an important element to bear in mind. And then on C332, we're in favour of that bill. We made several recommendations that we wanted to integrate in the first reading of this, and when we were able to present before the Justice and Human Rights Standing Committee, we shared these recommendations, and the most recent version has taken up most of our recommendations, in fact. Now, the bill and the criminalisation as such is not sufficient. We can't just criminalise this and hope it's going to wave a magic wand. No, there need to be essential conditions in place that we mentioned in our opening remarks. Perhaps you'd like to add something, Louise? I think we have to talk about the training of the professionals. There need to be adequate resources so that this can be integrated into new practices. There needs to be awareness raising amongst the population, and we have to think about talking about perverse effects of judiciarization of coercive control and discuss this with victims and with marginalized groups to avoid these possible and desirable effects. So there's lots of measures that need to be set up even before the entry into force of the bill.
Thank you. We have Leah Kazan. You have 2.5 minutes.
Thank you so much. My questions now are for Madame Parsa. You spoke about systemic oppression and the misapplication of the law. You spoke a little bit about mandatory sentences. How I'm trying to figure out how to phrase this. For BIPOC communities, why is the criminalization of coercive control more of an issue?
Sure. Thank you for that question. I think there's two main reasons that we've raised. The first is that if you look at the history of the criminal law, and if you look specifically at something like mandatory charging and domestic violence policies, you'll see that often violence and abuse is treated differently when faced by BIPOC communities. It might not be it's not understood the same way by police officers, by members in the legal system, and often this leads to the victim being charged as an aggressor. Studies have shown that this happens at much higher rates with Indigenous and Black women, where they are identified and charged as a primary aggressor in a situation of domestic violence when they were really the survivors there. So that is a risk that we really think should be taken seriously with any new criminal offense. And the other one is that marginalized communities, racialized communities, disabled women, queer communities, all of these groups, they have valid and historical reasons to distrust the police and the legal system. And so relying on the legal system and the criminal justice system as the solution, in effect, it kind of it sort of places these people outside the system and outside an ability to seek help. It allows for certain communities to be able, people who feel more comfortable, I guess, going to the legal system and talking to police officers might feel like they can access this criminal law, but many of these communities would not want to seek out for this.
So what would you recommend as the alternative?
I think what we would recommend as the alternative is like I've said, funding for social services, funding for housing, and education. So I think having education for frontline providers, having education for social service workers, that toolbox that was being spoken about, I think that's a great idea, so that people are aware of coercive control. And so if this kind of, if these events are being seen, people will understand that this is abuse and someone might need help. I think social services and kind of housing and as you were saying, basic income, I think all of these should be prioritized.
Thank you.
Dana, thank you, Leah. Thank you to all of our first panel. At this point, I think a few people have mentioned it. I know Anita did as well with regards to the toolkit for it to be tabled. Perhaps we can have the clerk request an electronic copy, and then we'll be able to have it. Further to that, thank you for all of the witnesses for your testimony. We're going to pause for a few quick minutes. The next panel is all online, so we're going to do a quick change for that, and then we'll get moving. Thank you.
Thank you.
So we will suspend for about 4 or 5 minutes. The committee will resume our meeting and the study of coercive behavior. We are now with our second panel of witnesses. I would like to make a few comments for the benefit of the witnesses. Before speaking, please wait until I recognize you by name. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Those in the room, your mic will be controlled. There is no one in the room, so we're good. You may speak in the official language of your choice. Interpretation services are available. You have the choice of either English, French for your earpiece, and if interpretation is lost for all those online, just let me know with a wave of your hand and I'll be watching. At this point, I would like to welcome our witnesses. We have Laurie Chambers, professor of Lakehead University. We have from le Regroupement Québécois des Centres d'Aide et de lutte contre l'agression à caractère sexuel. We have Gabriella Comtois, policy analyst. And from the YMCA Hamilton, we have Amy Deschamps, director, housing and gender-based violence support services. So you will each have 5 minutes for opening remarks, followed by rounds of questions. At this point, I would like to give the floor to Ms. Chambers to start. You'll have 5 minutes. Thank you.
Wonderful, thank you. And you can hear me okay? Excellent. Okay, so coercive control is it's a very gendered behavior is the starting point, and that is something that is too often neglected when we talk about intimate partner violence. And it is a range of acts designed deliberately to make a person feel subordinate, dependent, and to isolate them from sources of support and escape from a relationship. It can include violence, but it doesn't have to, and it's extremely difficult for people to recognize from the outside, and sometimes difficult for people to recognize for themselves that they're experiencing coercive control. But it is a high-risk situation for fatality when someone is experiencing coercive control. It is much more predictive of femicide than any physical violence that a man can take against his partner. And the tactics of coercive control are quite straightforward when you list them, but they're harder to see. So I think the greatest challenge that we face is that most people don't really understand it. So it is the use of intimidation, isolation, control and deprivation, sexual assault, economic exploitation, and legal harassment to strip someone of their autonomy and personhood. It's a fundamental assault on a person's autonomy in all ways. So you're threatened, you're surveyed, you're degraded repeatedly. This may be accompanied by violence at the beginning of a relationship or at any time to confirm control, but after that, behaviors may just be a threat of further violence and nothing else is ever necessary. It is quite common for people to say, well, he didn't hit me, so I don't think I was being abused. But that does not mean that abuse, and actually very dangerous abuse, is not present. And technology actually feeds into this because GPSs, small cameras, smartphones, audio and video recorders all make this easier for perpetrators to continue their control, even from a great distance. No matter where you go, he can still find you and he can still harass you. Isolation, their access to their family, friends, and other people's sources of support is often really cut off. Their resources and capacities and abilities are used for the benefit of the perpetrator, not for the person who's being abused. So you're deprived of the means of independence, of even control of your everyday life, told what to wear, what to eat, when not to eat, when you can go to the bathroom. It can be very, very pervasive, all controlling every aspect of your life and identity. And this means that people gradually lose the ability to make decisions for themselves because they're not allowed to do so. And this makes it difficult to leave. Sexual coercion. We don't talk nearly enough about the fact that sexual violence is 100% part of coercive control. Victims who are experiencing coercive control are assaulted. They may not think of it as rape because we don't, as a society, recognize that rape occurs in ongoing long-term relationships. We minimize it. We think of it as people owe sexual, particularly women, owe sexual performance to their male partners. And so women, but if you're asked to do something or told to do something or forced to do something, because there will be bad consequences for you if you don't, even if you're not punched as you're raped, it is sexual coercion, and having to do things that are distasteful to you at a time when you don't want it, that's part of the pattern of coercive control. Financial control, economic exploitation, taking out credit cards and loans in your name, leaving you indebted, taking away your ability to work, sabotaging your ability to get to work, to have friends at work, allowing you only a very small amount of money to buy food for the family, so that then you're going hungry and you can't do you can't save any money whatsoever to do anything independently. Employment and sabotaging your employment so you can't keep a job, restricting your ability to get an education to improve your situation. All of these are characteristics and facets of control. And if you do manage to leave, legal harassment. This is particularly terrifying and terrible when women think they might have escaped, and then the perpetrator throws at them, stalking and harassment and potential violence and threats and following and being with their kids all the time. And then custody agreements, you have to go to court and you're being gaslighted about what you did and what he did. And these patterns are not recognized by police, so if you call for help, it's not seen. And if you go to family court, it's not seen. And we know that women and children are dying because of this, and we need to have a much better understanding of how these tactics work together, and far better training for all the services that are responding, and more money in women's hands so that they are able, and housing and options for them to leave.
Thank you very much for that. We're all well aware that 5 minutes goes so quickly, and I'm sure on many occasions we'd love to have 10 instead, but just in the nature of time, we will move on to Ms. Comtois. You have 5 minutes.
For over 45 years, the regroupement has had an exchange of expertise between its members and to help with finding solutions to combat sexual assault and develop help in an intersectional way for women across Quebec. And for FEWO, coercive control is not just an individual problem, but a collective one, because there are unequal relations of power, and we're talking about controlling behaviour to try and subordinate women with levers of domination, such as discrimination and violence. And as a national group, we would like to point out to the committee that there is this notion of sexual coercive control that's extremely important. According to Tanya Palmer, sexual coercion we're talking about coercive control, can actually gradually erode the autonomy of the victim over time. So it's the routine nature of these sexual assaults which sets up, for example, constant touching, denial of intimity, and one single person is deciding when sexual relations should take place, and this eats away at the autonomy of the victim. In other words, coercive control creates a general climate where it is not possible to actually give free, informed consent for sexual activity, and refusing to enter into this relationship can have consequences, in particular if there are other forms of violence such as physical and psychological violence that are present. So sexual violence should not be looked at in an isolated way. Rather, this should be seen as one of the manifestations of this continuum of tactics that are used by the aggressor to maintain the victim within this violent situation. When it comes to possible solutions within our regroupement, we're very much concerned about the fact that criminalization is the main government strategy to stop coercive control and to remedy this situation. Criminal measures, in fact, should just be one part of a more vast strategy. In Canada, there's only 5% of sexual crimes that are actually reported to police, and we know that people, such as Indigenous peoples and Black and racialised women and women with disabilities and people with precarious immigration status or members of the LGBTQ plus communities are more prone to have a negative relations with the legal system and are less likely to report when this type of thing occurs. And there's more than 55% of the Canadian population who do not fully understand the concept of sexual consent. We're inviting the federal government to look at the question of education amongst people and awareness-raising campaign to stop violence before it actually takes place. Organizations that are fighting against sexual violence are really at the heart of developing these prevention and awareness-raising campaigns within Canadian society. Requests are coming in and increasing over years, and there's an absence of resources, and that is leading to an increase in waiting times for victims to be able to get the care that they need to actually move towards healing. So the federal government has to ensure that these organizations are equipped with adequate resources to carry out their vital work in our communities throughout Canada in terms of prevention and awareness raising. Finally, one of the main factors that maintains women within this type of coercive control dynamics is because of the economic imbalances and inequalities that were mentioned by previous witnesses in the committee. And no doubt this is an issue that will be raised once again. So economic inequalities continue, and economic gaps force women to put themselves or remain in dangerous situations to keep a roof over their heads and meet their basic needs. So for our regroupement, we have to attack this problem of economic inequality so that we can allow women to escape from their aggressors and abusers. We've seen the National Action Plan to End Gender-Based Violence that has come out. That's an action plan which we have welcomed within the RQ-CALAX, our association. But EVA Canada has pointed out that the sexual violence actors have been left out of the national action plans. We'd like to ask the federal government to give more resources and more space to community organizations trying to tackle sexual assault cases. And we have to actually deal with sexual violence and other types of violence together, because there's IPV, which is one part of this, and that's part of the overall domestic violence context. It's part of a continuum. We should not deal with these two separately. So we think that we can actually enhance the National Action Plan in the years to come if we can give more importance to associations working to counter sexual violence.
Very much. Ms. Deschamps, you have 5 minutes.
Thank you, Madam Chair and members, for the invitation to speak before you today on the matter of criminalization of coercive control. I bring my testimony from the traditional territories of the Haudenosaunee and Anishinaabe people. I'm the Director of Housing and Gender-Based Violence with YWCA Hamilton and have close to a decade of frontline experience in the VAW sector, as well as am a survivor of childhood family violence. At YWCA Hamilton, we have served close to 2,000 individuals over the past year whose lives have been impacted by gender-based violence across a range of preventative and responsive programs. And we strive to center the voices of those with lived and living experience, as well as our frontline staff in our work and in our advocacy. And so while there are key cross-sectoral responses that acknowledge the role of legislation and enforcement in the work to eradicate gender-based violence, many of the survivors that we support, particularly those from marginalized or diverse communities, would identify that their experiences within these systems have not led to better outcomes for themselves or their children. These systems have had some but limited success in addressing reoffense through existing means of intervention and monitoring. And so we know that gender-based violence, as we've heard today, is rooted in patriarchy and systemic oppression, and that any law, policy, or response is also vulnerable to these failings in its application. We see this in the rates, as been mentioned before by other witnesses, of dual charging and the increased rates of survivors being solely charged with the introduction of mandatory charging. And we also see this demonstrated in the higher than average rates of gender-based violence that we know exist where perpetrators have access to firearms in their jobs and higher than average degrees of authority over communities. And so to meaningfully address and increase safety for survivors, where strengthening and improving the legal system is critical, I want to echo research and evidence-based backed steps that we believe should be taken in advance of any introduction of coercive control into the criminal code. And these are highlighted by many of the previous testimonies that have been given to the committee, such as the powerful testimony by ED Neka McGregor of Women at the Center in 2022, as well as really important publications put forward by Owaith and Luke's Place on this topic. And I think it's been spoken to really significantly already today about the challenge of accurately capturing the various forms and nuances.
Excusez-moi, Madame Deschamps. Excusez-moi, Madame Deschamps. Madame la Présidente.
Excuse me, Madame Deschamps. We don't have any interpretation.
Okay, so I'll continue to speak and see if Dominique.
C'est bien, c'est revenu, merci.
Okay, we're good?
Oui.
Okay, Ms. Deschamps, please continue. Sorry to interrupt. Thank you, Dominique.
No problem, thank you. And so picking back up, with current system that does not address appropriately even the most overt and physical forms of violence, I am doubtful that our system as it is has the ability to respond to the complexities of coercive control that my colleague Laurie Chambers spoke to so eloquently. In our current context, proving coercive control can be difficult as it often relies on patterns of behavior and psychological manipulation rather than physical evidence. And so the burden of proof sits on the survivor, which often leads to, perhaps disappointment in the court system and further re-traumatization for survivors. Coercive control also often intersects with other forms of oppression, such as sexism, racism, classism, and ableism, and legislation must consider how these intersecting factors affect individuals' experiences and provide survivors with opportunities to have options for support outside of these systems should they choose not to want to take part in them. So, for example, looking at transformative, restorative approaches. Adequate resources and funding to existing services such as VAW shelters to adequately address the safety, housing, cost of living, and childcare needs of survivors are far likely better able to achieve the outcomes in providing upstream and preventative responses that we're looking for. And I know all of us here have a shared goal of increasing safety for survivors and holding those who use violence accountable while mitigating the unintended consequences of policy decisions. But we need to begin by addressing the root inequities present within the existing legal and law enforcement landscape to address these issues in traditional ways that we have been attempting, but failing, to be quite honest.
Very much, Ms. Deschamps. Thank you very much. At this point, we will move to questions. Anna, in the nature of time, and I want to get as many questions in as we can and with respect to our witnesses, so we're going to reduce first round to 5 minutes each. Anna, 5 minutes.
Thank you, Madam Chair, and thank you to the witnesses. This is a very important topic. So I'm going to start with Laurie Chambers. Ms. Chambers, a yes or no answer. Do you agree that coercive control is a gateway to physical violence? I didn't. You're on mute. Okay.
It's the wrong way to conceptualize it as a gateway. It's.
I want to just go back because I have limited time.
But violence is just one of the tools in the toolbox of a coercive abuser, and they won't necessarily use it. So it's not a gateway. It's not like the gateway image is not appropriate.
Okay, so I want, because I have limited time, I'm so sorry, Ms. Chambers, but I want to bring up two cases. One in April 1997 by a husband who killed his 4 children, sons 15 and 14 years old, daughter 12 and 11 years old, his wife Helen 36 years old, and your case of December 2017. So 20 years apart, we have the same situation, and these individuals are not being punished. We've provided them, they ignored the courts, They've ignored the restraining orders. The system failed them totally. How can we protect our mothers, our children, and our families? I mean, education is great, but in some instances, we have to listen to the children. We have to listen to the parents so that we can protect these individuals. Do you agree with that?
I agree. We need, particularly the case that you highlight that I talked about in 2017, the judicial system failed, and judges need to understand this is a part of the system that no matter how much you might want to avoid it altogether, you can't necessarily if you're leaving. You have a custody dispute about where your kids are going to be. And people interpreting family law have to be taught about coercive control. Those two little girls would still be alive if the judge had understood coercive control and not missed what were some pretty serious red flags.
So let me ask you something. So 20 years ago, this particular individual received counseling, education, the whole 9 yards. He had restraining orders. They worked with him, and they finally said, "Hey, you know what? He's okay. We're gonna let him see his kids." And guess what? It was all an act. And he.
You shouldn't.
And the reason I know about this case is because.
They should never see them again.
Exactly. So my point is, sometimes we have to take that line to ensure that we protect our kids. So coercive control, to me, if we can't protect the victims, the young children, the parents, the mothers, how can we? I mean, this man received tons of education, and I know the case personally because I was involved with it. And you know, they said, "Oh yeah, he's gone through it the whole bit," and yet 20 years later, here we go again. Nothing's changed. Nothing has changed. He should have gone to jail. Do you agree with that?
I agree, but I'm not. My primary concern isn't whether the man goes to jail. It's keeping the children safe, and so keeping the children safe would involve better understanding at family court is more important. Better options for the mother so she can leave the jurisdiction, go with the kids somewhere else where they are safer.
But
education is more important.
I understand that, but and I'm sorry to interrupt you because I have limited time, but
Anna,
Ms.
you have
Chambers,
1 minute, okay?
Thank you.
You have 1 minute.
Thank you. Ms. Chambers, I know this other case that happened in 1997, and this man went through extensive education, extensive therapy. It did not work. Sometimes we have to accept the fact that individuals cannot change. So what I'm asking you is, in those particular cases, we not only have to educate the law system, our social workers, the therapists, we have to make sure that we're listening to the children. Do you agree?
For sure. Those kids were afraid of their dad.
We let them down. So I think that we need to put in place to criminalize coercive control. I really believe that that's the only way we can protect our children, and I'm wondering if you agree with that.
I'm hesitant about criminalization without a whole bunch of backstop stuff.
At this point, we're going to have to leave it at that. I'm sorry. We're going to move on to Lisa. You have 5 minutes.
Okay. Was it not Emanuela next? I'm happy to go.
So.
But I think it's Emanuela next. We have 2 more speakers, right?
Oh, I did. Emanuela, you're right. Thank you.
Thank you. So I want to begin by thanking all of our witnesses for being here with us today. Very interesting testimony. I'm going to start with Ms. Chambers and ask you, I noticed that you did not mention parental alienation in your testimony. I was seeking it out because I wanted to ask a specific question about it. A few of our other witnesses in past meetings or even today have spoken and mentioned that they don't believe parental alienation should be used against mothers when it comes to family law. And so I'm wondering what your thoughts are on this. And also I want to, try to get a full picture as possible. I know that we have witnesses that work with women who are here, and I definitely want to be able to help and have at the forefront women and their children and the safety of women and children. I'm wondering if there's
ever been cases that any witnesses on the panel today have seen that where parental alienation actually is a concern? So I'll let you, Ms. Chambers, start with your comments on parental alienation, and then I'll hear from the rest of the witnesses.
Parental alienation is bad science. It's the evidence that was presented is not based in good research. It is not a real problem. It's a problem that is used by coercive men to gaslight and discredit their partners, and it is a big problem that it is taken seriously in the courts. It's a weapon being used by abusive men. I would absolutely not give it any credence in the court system whatsoever. Bad science, junk science, and courts shouldn't recognize it at all.
Does anyone else want to comment on that?
I can just echo what Lori has shared, in that often we just see that being used as another form of abuse. We know that children are often used as pawns, as was spoken to earlier, in the custody and access process, and one of the most powerful weapons of coercive control. In the reality that we know, there is no greater fear than a mother has than loss of control, loss of life of her children, and these are often threats that are made by an abusive partner. And so I would have to agree and echo those sentiments as well, that there is no place for that in the court system.
Est-ce que je peux rebondir également?
Could I please intervene as well? I'd also like to bring up the idea that it starts a long time beforehand. The control of the aggressors over the life of the victims really happens a long time before reproduction. For a child, there's already this power and this domination that's exerted when it comes to the choice to have children or not, the choice to use contraception or not. So the control over children starts even before they're conceived. So I wanted to talk about reproductive coercion, which is part of the continuum of the violence that is experienced by these women within that overall abusive situation.
Merci beaucoup. Thank you guys for your answers. Je vais continuer avec vous, Madame Comtois.
And I'll continue with you, Madame Comtois. You've talked about the fact that it's important for young people and the population in general to have more education about.
Et puis j'aimerais savoir.
And I'd like to know, what do you think the Canadian government can actually do specifically on that level?
Donc,
answer. In our statistics, we've seen that there's 8 people out of 10 who actually know their abuser, and there's over half of sexual assaults that are carried out in private homes, private residences. So we've seen that there's a myth that exists when it comes to the population general law that sexual assault is always committed by somebody in a dark street that we don't know. But more often it happens with someone that we already know. So to stop violence before it actually happens, well, it's crucial to have awareness-raising campaigns amongst the population. So I think the Canadian government can intervene there with advertising campaigns, for example, ads, educational videos, because we have to have a culture shift. There is normalization, banalization of these situations, and it's not the community associations, but it's families and the people close to us who can recognize these types of conduct and who can then realize that they're enabling aggressors and abusers to continue with that type of situation. Of course, community associations play an important role, but it's the community that is the first bulwark.
I didn't waive my first 30 seconds, so I think I confused you.
Thank you to the witnesses.
Thank you. Adrienne, you have 5 minutes.
Merci beaucoup. Thank you very much, the witnesses, for being here for this important study. In Quebec, we want there to be criminalization of coercive control. I'm going to kick off my questions with you, Gabrielle. You have said that, yes, there's a national action plan in place, and you've said that in this plan you deplore the fact that the question of violence for associations working to stop sexual assault is different from other forms of violence and that it's all being done in silos. So what do we need to change in the National Action Plan so that we can stop this type of violence against women? Can you tell us a bit more about all of that, please? Well, the big problem is, in fact, a resource-based problem. Since COVID-19, from one year to another, we've seen a more and more marked increase of people who come to our services, survivors who want to use our services. And also after the Me Too movement, we see that people are not waiting as long and they're coming earlier. So prevention is working. The only thing is that we're totally overwhelmed. The waiting lists are getting ever longer. The frontline workers can't keep up with the pace of the requests for services. They can't provide appropriate services. It's too much for them. And we're working for resources that are basically half of what we would need to be able to work well. So with the National Action Plan, we could have some more funding for the missions of these associations, because for the moment we're mainly project-based funding, and that's all fine and well. But with each project, there's even more responsibilities that come along. And when we've got waiting lists of over a year, if we have to absorb more responsibilities and steer a new pilot project, isn't really what we need. It's not going to allow us to respond to these needs that already exist and that are continuing to increase. So that's my response. Perfect. Question. I don't know if you've seen that article in La Presse this morning, because you talked about the requests that are increasing and the lack of resources, and there's these 14 femicides that have taken place in Quebec this year, higher than in the whole of 2023, and we're only in the month of May. And Madame Grandmont, the journalist, says that Quebec groups are asking for a bill. There is a federal bill, C-322, that's been studied by the Justice Committee that talks about criminalization of coercive control. But in the article, it says there's not a unanimous position. Certain people saying that the definition of coercive control is vague and that certain acts are already criminal. The fact that you're intimidating someone by, for example, carrying out surveillance via their mobile phone. Now, you've been talking about the fact that there's an accumulation effect. There's all these different tactics that build up over time, and there's different forms of coercion, as you've explained. So do you think we've got enough measures under the criminal code to already recognise that type of surveillance and these types of threats, for example, surveillance by cell phone? Answer. Well, currently, ideally, courts and judges have to recognise coercive control as a contextual factor. We've got certain elements that have already been criminalised under the Canadian Criminal Code, but I think we need to tread very carefully when it comes to promoting criminalisation of coercive control, as has been said by some of my counterparts that have appeared in this committee and in the previous committee, and as we've also heard from the NO experts. We don't have enough information yet currently to actually promote that type of criminal law-based measure. But as I've said, coercive control is part of a continuum. Judges and judicial actors have to be made aware of this. They have to understand it so they can take this into account. But what I would suggest is that this should be taken into account, but not necessarily be set in stone in legislation. I hope that answers your question well. Well, what I'm taking away from this first round, you've also talked about economic inequalities, and my colleague will come back on that in the second round. But you're saying you want to have a national action plan which gives you more funding, predictability, and also some more tools under the criminal code to be able to intervene more frequently. Is that a good summary? Yes, absolutely. Thank you very much.
Excellent. Thank you for that. Next, Leah Gazan, you have 5 minutes.
Thank you so much, Chair. My first question is for Madame Deschamps. You said in your testimony that you were doubtful our systems are capable of criminalizing coercive control, one of the reasons citing the burden of proof is left on survivors. Can you expand on that?
Absolutely. I think even just in thinking about where the assessment needs to start in the training of the officers on the ground in assessing the situation and the nuances and complexities of an individual or survivor trying to explain her stories and the impact of maybe a look or the many, many instances over a span of time of this type of coercive control that have been played out in her relationship. The individual across from her, the officer taking her statement, needs to have the training and assessment and ability and will to carry that forward and identify that. And I think the problem starts there.
Yeah, so I'm interested because how can you criminalize something when there's still not really an understanding of what that looks like by the people that are enforcing the law? And that's becoming very clear to me. But you also mentioned something about individuals that have power, like within their jobs, like access to guns. Can you expand on that? I was interested in it. What do you mean by people who have access to guns? Who is that?
So I think we've seen recent studies and reports about the rates of perpetrators of violence that are in law enforcement, and that the rates of that are actually significantly higher than we would see in the general population. So there's been several studies done that I think the percentage is 40% of partners of law enforcement officers are at risk versus 10% in the general population. So
I'm also, just because I have limited time, and this is very important, I asked that because I did ask in another meeting, because I am aware of high rates of domestic violence that are perpetrated by police officers who then would be tasked with the responsibility to press charges, but they're also perpetrators of violence. That's a bit of a conflict of interest in my opinion. You were talking about, instead, let's invest, and we heard this in former testimony, supports outside of the current system. I know in my riding where we have a crisis of gender-based violence, the ground zero for MMIWG, Winnipeg's never had more money invested in policing. I've never seen our community and rates of violence increase to the levels that it has. And at the same time, we've seen decreases in supports. One of the things that I've put forward in a bill is to put in place a guaranteed livable basic income addition to current and special supports meant to meet specific and special needs. Would that help, yes or no, with dealing with the frontline crisis of gender-based violence, particularly individuals trying to flee coercive control? That say yes or no, because I'm going to ask all of the yes.
Yes.
Madame Chambers, Professor Chambers, yes or no?
Absolutely, it would be helpful.
Yeah. Madame Contois, yes or no? Guaranteed livable basic income?
Absolutely essential.
Absolutely essential. Okay, great. Professor Chambers, you gave a wonderful definition of coercive control. I know that we've, been trying to find a definition of coercive control, and I can see a white card there. Now, with your definition of coercive control, is this a new concept? Would you say it's a fairly new concept?
It's about 20 years old. It started really with Evan Stark and grew out of the power and control wheel from the Duluth model 20 years before that. But the details have filled in more with time, with more and more examples coming from real life and talking to more and more victims. And so one of the things that I have sent to the committee is a checklist that we're using now locally.
Yes.
That is really detailed about questions to ask to identify.
So I did see that,
control.
And I only have a couple of seconds left. Would you say that we need to have more research done before we criminalize coercive control? Yes or no? And then my time will be up.
I think the research is there. I think what we need is more education, because the risk of misinterpretation of the law with the current problems that Amy was talking about, and the risk racialized enforcement and
Thank you very much, Ms. Chambers. Because of the nature of time, I would like to get a second round in. We do have resources for a little bit longer, but we still, because this is powerful testimony, but I still am going to shorten the next round to move us along. So Dominique and Lisa, you will both have, so Conservatives and Liberals, you'll both have 3 minutes. And this was a block study that was put forward, so I'd like to keep you at 2.5 and Leah at 2.5 as well. Are we comfortable with that? Yes. All right. Dominique, you have 3 minutes.
Merci, Madame la Présidente. Madame.
Thank you, Madam Chair, and thank you, Ms. Laurie, for being here. I don't have much time, so I'll go straight to the question. I'd like to also refer to the article that was raised by our colleague Andrea. I read it this morning, and it sent shivers down my spine when I looked at the statistics, but there was an interesting angle in that article. It said that to act upstream, Quebec could also draw inspiration from the Clear Law, which lifts the veil on the past of her spouse. That was after an assassination that took place in the UK. So provinces have adopted this possibility of gaining information about a violent man. And what has been said here is that in the shelters, and in particular out in the regions, we're aware of the fact that often women are all victims of the same man, the same perpetrator. So, Madame Laurie, what do you think about this? It has been rolled out in Alberta, Manitoba, Newfoundland, Saskatchewan. It hasn't been rolled out in Quebec currently. Have you heard about this law, and what do you think about it?
I think it's a great idea. The more information women can have in their hands, the better. And so being able to get that information publicly about someone so that you avoid dating them there's no downside to that. And it originated in the UK with Clare's Law, and I think every province should have a Clare's Law.
Madame Laurie, dites-moi.
Madame Laurie, one of your colleagues earlier, I don't know if I correctly understood, but she talked about a certain profile of this toxic person who almost enslaves women. Now, amongst the population, what would be the incidence level? Is it 1 out of a million or 1 out of 500,000? Is this element actually documented, this typical profile, if you like?
We don't really have a profile in terms of, we don't have a lot of statistics because we don't have the cases before us except the ones that go violent. We don't know all the cases that don't ever get litigated. We don't have all that evidence, but the ones where, if you look at the patterns of who dies, it is overwhelmingly white privileged men who kill their partners. And it is overwhelmingly those same men who then might engage in mass violence, who practice on the women in their lives first.
Wow.
Et sur, je ne sais pas si je ne vois pas la présidente. Je ne sais pas si elle m'a.
I cannot see the chair. I don't know if I've still got time or not. How much time do I have left?
No, malheureusement, no.
C'est terminé, merci.
Oui, c'est terminé.
It's finished. Thank you very much.
You have 3 minutes.
Thank you, Chair. And I want to thank all the witnesses that we've had here today. It's been a phenomenal a difficult but very important conversation. Also, very little time, but I'm going to go to you, Amy, from my beloved local YWCA Hamilton. Thank you for being here. I really appreciated in your opening statement how you explained how victims can be traumatized by a court process if coercive control is criminalized, because it's not based on evidence that police can clearly find. It would be up to the victim to come up with, I don't know what kind of proof she'd come up with in a court of law to try and prove that she's been living under coercive control. So my question is, if we don't have legislation against coercive control, what do you think is the best way to address it? And is there a way to make the justice system work better with the family law system?
Thank you. I think absolutely that there needs to be better integration between the criminal justice system and family law systems, because we know that these things, particularly where intimate partner violence is considered, cannot be separated. I also would say that we have to look to the realities that the current system does not work for many of the individuals, women, children, marginalized individuals who are experiencing it. And I think that if we look to where the challenges are presently and we start there, my worry in criminalizing coercive control is that we're assuming that it's going to be a check mark in addressing this instance and this issue. And there's many other opportunities that we can look to try to make change. We have 86 recommendations that came out of the Renfrew County inquest that lays out a roadmap for us to really invest in the types of change needed to make a difference. So I see criminalization of coercive control as one piece of that puzzle, but by far a lot of work to be done ahead of that in order for, again, the people assessing on the beat to be able to make those right decisions. Our systems need capacity. We need time and resources to invest in training of our officers, frontline staff. Our system, as it stands as a VAW sector, is crumbling and under-resourced and over-capacity. And so looking at the real solutions there, I think, is the place to start if we want to make real change.
Very much, Amy. And Professor Chambers, I'd like to go back to you. You said in your opening statement that coercive control is more indicative of femicide than physical violence. Could you explain that in further detail for us, please?
Well, in about 25 seconds, if that's okay.
Okay, well,
Thank you.
A lot of the time physical violence is just the result of people getting angry and fighting or whatever. But femicide happens, it's planned. It's men who are in control, and when they lose control, rather than lose control, they kill. And it's planned behavior.
Well said. Thank you very much.
Thank you. Next, Gabrielle Saint-Marie. You have 2.5 minutes.
Oui, merci, Madame la Présidente.
Thank you, Madam Chair, and hello to my colleagues and the witnesses. I've got a question for Madame Comtois. In 2.5 minutes, I'd like to hear from you about this issue of economic violence and control of resources. And if you have time, could you talk about the difficulties to prevent and stop this type of conduct? Thank you very much. Response. As I said, one of the most essential resources is, of course, the community people who are close to you, your family. They are the first people who can actually act and help you to identify what's happening and give you access to resources. And then, of course, there's all the frontline organizations such as CALAX and the Shelters Association that will be able to help people to gain access to resources so that they can start on their healing journey. Then, of course, there's more specialized services that exist depending on the needs of the victims. But in several provinces, well, in fact, a woman has various overall needs. Like other human beings, she needs a roof over her head. She needs to have access to health care services. She needs access to work, and there's obstacles at all levels at the moment because there's the housing crisis. In Quebec, it's very difficult to gain health care, in particular when you're a woman. Lots of difficulties, difficult to gain a footing in the labour market compared to their male counterparts. So they encounter obstacles at every turn. So if we can guarantee a basic income, I think that could allow these women and victims in general to be able to get out of these situations, or at least put a chance on their side so that they can improve their overall living standards, living conditions. We've got several women who come to the centres and they're really not able to start with their healing journey because they have to respond to their most immediate basic needs, such as feeding themselves and having a roof over their heads. Then afterwards they can start thinking about healing. There are, of course, very different individual trajectories out there, but it's like a hierarchy of minimum needs that we need to respond to. The Canadian government absolutely has to deal with this issue to meet these basic needs.
Lastly, we have Leah. You have 2.5 minutes.
Thank you so much, Chair. And you know, it's very clear to me listening to the testimony, we focus on punishment. But if we're really serious about eradicating gender-based violence, and we hear, you know, meeting after meeting after meeting, we need affordable housing with rent geared to income. We need a national child care program. We need a guaranteed livable basic income. I think we know the solutions. We just lack the political will sometimes to push it forward. Now, I wanted to ask you, Professor Chambers, you were talking about profile of abusers. I'm wondering if you can expand on that, because we're talking about issues in the criminal justice system, especially for BIPOC folks. I know that in Winnipeg, the last one who wasn't formally convicted, and a case that's currently happening, serial killers, in fact, were white males.
Mm-hmm.
So I'm wondering if you can speak further to the profile of a you know, knowing that, you know, impact violence is found in all cultures and groups, but the typical more prominent profile of somebody. Yeah, go ahead.
The serial killer and mass casualty incident people are overwhelmingly white men with some level of privilege. They're not your most disadvantaged people. BIPOC people are much more likely to be subject to criminal sanction, and white men who practice these behaviors with their intimate partners for years before they engage in serial killing or mass casualty incidents don't get called out, don't get considered to be violent because they are protected by the system that targets other men. And so their partners are at risk when those behaviors are missed, right?
So this is concerning for me because I do know that we have systemic racism that's very predominant, which is why I'm concerned about criminalizing coercive control. Because if you look at profiles of abusers, they're historically been protected by systems. Would you agree with that? Okay, thank you.
Thank you, Leah.
Thank you, Chair. You're so graceful with the card.
I'm not going to go like this. So that will conclude our second panel. On behalf of the committee, I would like to thank all of the witnesses for your appearances and providing your testimony. As a reminder as well to all members, we will start studying V1 of the report on the red dress alert, which was distributed to, will be distributed to everyone today. Other than that, is the committee in agreement to adjourn the meeting? Yes. Excellent, thank you. Meeting adjourned.